Well, ladies and gentlemen, good morning or good day, good evening, wherever you are, whatever time zone you are in. Welcome to the third installment of Module 1. Without any further ado, thank you so much. Over to you, Marika.
Thank you, Tim. Yes, let's get going. This will be our final installment for Module 3. For Module 1. Part 3 will be our final installment. And today we're going to have a look at, we're going to start with the fundamentals of contracts. So, what is the necessities for a contract to be binding and for it to go forth into a transaction and essentially into a registration of transfer in the real estate sector. Right, so for a contract to be legal and binding, especially in the real estate sector, it must be in writing, right? We can't just shake hands and say, I, Mr. Buyer, buys from you, Mr. Seller, and this is what I'm buying, this property, and this is the money that I will hand over to you, right? So an agreement is just that or a contract rather, is an agreement between two or more parties with the intention to establish a legal obligation, right? So that binding of the contract is to establish that legal obligation, right? So it must be in writing. It must be signed by all parties involved. It must be bilateral, and there must be rights for monetary compensation, right? So if we say it must be in writing, meaning there must be a document setting out the terms and conditions of this transaction. It must be signed. Yes, that's quite obvious. Signed with a pen by all parties. Bilateral meaning that it should be written in such a way that it looks after both parties, right, or both sides of the agreement. And the rights for monetary compensation is there must be some sort of agree or a condition saying that what I'm purchasing I will get if I give you, in this instance, immovable property, right? And that goes for both sales and for leases, right? So if we look at a bilateral contract, is a reciprocal agreement between two parties in which each party promises to perform an act in exchange for the other party's promised performance. Right, so let's use an example of a buyer and a seller. A seller will promise to perform an act in exchange. So that act is, I'm giving you my property, my immovable property, for the other party's promised performance. Right. So let's say that's the that. Sorry, let's go back. Between two parties in which each party promises to perform an act in exchange, that's the seller. The seller promises to exchange something, right, to the purchaser, which is immovable property. For the other party's promised performance, that performance is, I'm going to give you money for this property. Right, so in order for an agreement to be legally enforceable, documents between parties consisting of an offer, right? So your purchaser will make an offer. That's the first step. Remember, it needs to be in writing first and foremost. It needs to be signed. Then it goes to the seller, which needs to accept it, right? So that's where step 2 comes in, the acceptance of the offer. Again, it must be on that same document, it must also be signed by the seller. Then we're looking at consideration, right? So consideration is what are the terms and conditions of this contract. There might be special conditions, there might be resolutions to it, etc., etc. Right? So terms and conditions in that contract. There must be legal capacity, meaning that all parties should be willing and able, and there must be legality of the purpose, meaning that this exchange, this contract is legal within the laws of South Africa, right? So if it's, let's take an example. If it is a contract between a drug dealer and a user, it can't be a legal contract because selling of drugs is an illegal action in South Africa. Right, so what every single offer to purchase or contract or an agreement should contain should be first and foremost the property description. And not just any property description, the legal registered property description, information that we get from the deeds office. Right, so first and foremost, we should make sure that we are describing this property in the right suburb within the correct municipality, because earth numbers and portion numbers, there might be more than one earth number in the bounds of South Africa, but it is earth numbers in different suburbs in different municipalities. So very, very important is that we transact or we describe that property in the correct municipality, first and foremost, then in the correct suburb, right? And then we need to describe that property in terms of an earth number and also a portion number. It is very, very important because there also might be same earth numbers but different portions. And if I can give you an example on that, it is where a big property, let's say a farm, were subdivided or broken up into pieces, so they can, so it's the mother earth number that was given to that big portion of property, and as subsections has been registered, cut, developed, then they will still use the mother earth number but with a different portion number. So earth number plus a portion number, right? If none of that has ever happened, so the earth number, the mother earth number has stayed the same, there were no subdivisions, no cutting up, no portioning of that mother earth, then your portion number will always be 0, right? So make sure that we always add earth number as well as portion number. If there isn't a portion 1, 2, 3, 4, 5, 6, etc., then the portion number is always 0. And then we add on to that, we're going further with the street number and the street name of that property. This is now obviously just for freehold property, so freestanding property. But if we look at sectional title property, we have to describe that property even further. And there we should have a section number, we should have a door number, we should have a sectional title number, and a sectional title name. Right, so if we break that down a little bit, the section number is the actual section in the sectional title that was registered with the deeds office. Most times the sectional number will not tie, or it will not be the same as the door number. So you might find that in some sectional titles, section 1 is also door number 1. But that's not always the case, and we need to do our due diligence. We need to identify and verify that very well so that we don't make mistakes when we do draft our offers to offer to purchase. So oftentimes we see that, as an example, section 1 in a section title, the door number is 10 or the door number is 24 or 36. So very, very important that we describe the section number as well as the door number, and that correlates to a specific sectional title with that sectional title name, right? So we can use a good example like Groenkloof Estates SS. That is how that sectional title was registered, and then it's got a sectional title number, let's say 100 slash 2018, meaning it was the 100th sectional title that was registered in the year of 2018, right? So make sure that we describe that property very, very well, and that we do our due diligence, making sure that we have the correct identification and the description of that property. Right. Next, obviously, is price. Yes, no purchaser or buyer will enter into an agreement if there is no price, and price needs to be established quite early on in the sales process, and not just even in the sales process, but in the marketing process. One can't even market without a price, right? So your marketing will lead into your offer, your negotiations, ultimately concluding your sale. Also, very important, the party details, right? So, who is the purchaser, who is the seller, and also a pitfall sometimes because we often deal with an individual which are not actually the legal person to deal with in terms of that specific property. So, when one does your due diligence in terms of getting the property description, often you will also find that on the same document you'll find the party details as well, whether that is, like we discussed yesterday, a natural person, so just a normal individual that we're dealing with, or whether that is a legal entity. And if we can just quickly do a refresher on legal entities, those are closed corporations, also known as CCs, companies also known as PTYs, trusts, and then other clubs, religious institutions, or any other establishment. Right, so we need to make sure that our property description is correct, but also the party description is correct. If we have dealt with Mr. X in terms of a specific property, but that property is registered in Apple Properties Pty Limited, then we can't draft our offer to purchase in Mr. X's name. Mr. X is just the representative of the seller, which is the legal entity, as in this example, ABC Properties or Apple Properties or whatever the case might be. Right. Date's also very, very important. We have looked at the requirements of a contract, where one party says, okay, I'm going to make a promise to you in terms of you also making a promise to me, right? And that's where dates come in terms of I'm paying you an X amount of money for this property, and it needs to register. We need to put in those dates on when the money will be available in this example, or when any other agreement or term in that contract needs to be done. And then also very important, like we said, our agreements needs to be in writing and it needs to be signed, right? So we can do all our due diligence, we can draft that offer to purchase, but if it's not signed by the parties, then it is a null and void contract. Property law says that no transaction can go forth without there being signatures, without there being an offer on paper, in writing, signed, without being it accepted. If we look at agreements, also just worth our while to have a look at the different types of agreements, because we do get them, and they are different, and we need to make sure that we can identify and use them correctly, right? So a estate agreement is just a standard agreement between a purchaser and a seller where real estate is involved, right? So it's a very generic agreement, and it basically just states the things that we saw on slide number 40, or the previous slide, right? Property description, price, party details, dates, signatures, right? Normal standard agreement. Then we have a general agreement. Those are sometimes simply a shortened version of the above mentioned contract, and it's usually when real estate isn't involved, right? So sometimes that can even be a page. And then we have property specific agreements, right, where we use these for specific types of property, right? So either for vacant land or, as an example, a mobile home or agricultural land or commercial property. Then we have real estate assignment contracts. Most of us use these, right? These are specifically designed for our specific area that we conduct business in. It is designed and drafted for our specific property market. It is designed and drafted for our specific type of property in terms of sectional title or freehold property. And then we have lease agreements. Those are exclusively for the use of rental properties. And then, as we've discussed yesterday as well, power of attorney, that's also a type of agreement where one party gives the power to another to act or transact on their behalf with a specific timeline and also a specific action or a specific transaction in mind. Right, so if we have all of this, we have our contracts. There are certain things that needs to be done. Obviously, there should always be, and there will always be laws that are attached to these specific things. Right. So one law in specific that we're going to have a look at today is the legislation for immovable property transactions, right? So it's a law that was enacted in 2002. So it's a fairly new law, but it's been with us for a while, and this is to facilitate electronic communication and transactions, right? We spoke about this in earlier sessions that. These days technology is moving at such a pace, and obviously the laws need to keep up. We need to keep up to make things a little bit easier for on ourselves, and just to facilitate the transacting and the communications and the signings of legal documents in such a manner that it is still legal, right? So this law or this legislation, it makes provision for contracts to still be lawful in writing, as it should be, as we have seen, even if it is done digitally, right? It provides for the legal use of electronic signatures, and also that one can conclude any transaction online via email and executed with electronic signature, right? It has a legal force, but there are two exceptions, right? So, like the old saying goes, every rule has its exception, and this one literally does that, right? So this law says that we can, as property practitioners, we can transact with our clients easily via technology, right? So we can still draft our contracts, our agreements digitally. We don't need to actually handwrite out any details. We don't need to draft them in handwriting. It can be a digital draft. We can make digital changes to it. We can send documents via email, via easier platforms like WhatsApp these days. Back in the day, we used to use faxes. So we are allowed to do that. We are allowed to draft electronically, digitally. We are allowed to send electronically, digitally. And clients are allowed to sign digitally in order to make the offer. That's that first step of that agreement. They are allowed to sign digitally to accept the second step. And we are allowed to instruct to the attorneys and to financial institutions for credit approval, for any other communication, and for the transfer transaction. But that's where the buck stops. If it goes to the registration process, then this law says that we should have all our documents signed with a pen in wet ink. That's what they call it, right? So meaning that there is an original document that it has been signed, right? So there are also rules to that. Not only should it be with a pen, it should be in wet ink. Like I say, it should be signed. We can't just copy and paste a digital signature or a copy of a signature. And it needs to be in black, right? We can't use red or blue or green pen. It needs to be signed in a black pen, right? So as soon as it goes to the transferring attorneys, and that legal process of getting the registration done to transfer it from the seller's name into the buyer's name, it needs to be in wet ink, right? Right, so if we look at general principles of contract law, valid legally enforced agreements must now meet these six principles, right? So let's just remind ourselves again, always, if we look at an agreement, there must be an offer and an acceptance with a definitive agreement between the parties, right? So there should be clear lines. It can't be grey. There should be black and white on what those agreements are or what those terms and conditions are. And again, we can't enter into an agreement if it's not in writing and it's not signed and it doesn't contain all those terms and conditions, but information like the property description, the price, the dates, the party details, and like we see now, the definitive terms and conditions, right? So if we just call it out in layman's terms or in simple terms, one party must make a clear offer and the other party must accept it, right? So that is that first step in having a legally enforced agreement. Is there needs to be an agreement in writing, signed, offer made, accepted by the other party, right? Moving on to consideration. So, except in very limited circumstances, there can be no contract or agreement without consideration. And if we talk about consideration, what is consideration, right? Consideration is the exchange of promises, right? So that those terms and conditions, those definitive agreements between the two parties, right? And if we can look at a couple of examples, right? The payment of money, right? So, Mr. Seller, I am going to pay you a cash deposit, right? Within a certain time. Delivery of equipment. I will deliver specific equipment at a certain time. The promise to do or perform a service or work, right? We will paint the living room by a certain time, right? And we please pick up on every single time there is a consideration, a specific date is attached to it, right? We can't leave it open ended because how will we enforce it? If we say, let's just as an example, say that the consideration of this contract is that the seller will paint the living room, and that's where we leave it. We don't say it needs to be before registration of transfer or occupation or a specific date. How will we be able to enforce that? Then it's very open ended. We can leave it. We can't enforce it. And the seller can say, well, there's no date, I'll do it whenever I want to, right? So for every single consideration, whether it is a monetary consideration, delivery of something, a promise to perform a service, or an action to be taken, or to enforce, we need to have that date to enforce that right. Right. Moving on to intention, each person or each party entering a contract must intend to be bound by it. Right. So when we do draft that offer to purchase, when we do include those considerations, if we do sign that offer to purchase, right, the intent must be that we accept that we will be legally bound by it, right? We can't say, I'm signing this, but in 3 days, I want to just change my mind and walk away, right? So, for a person to be bound to a contract, you must seriously intend to create legal obligation and have intended the agreement to have legal consequences, right? So you should also understand the content of that agreement, and you should also understand not just the content but the legal consequences. So if any of your considerations is not met with, and you fall within breach, because that's what it's called, you are in default of that consideration, you're not doing what the contract says, what you have bound yourself to do, there should be legal consequences, and there will be legal consequences, and all parties should understand that. Right, moving on to capacity. Both parties in a contract must have the necessary mental, so you are legally willing and able to understand what you are doing, and that you can enter, you have the capacity, the legal capacity to enter into this agreement. Right? So, under common law, anyone has the right to enter into a contract, but there are some groups of people that are considered likely to lack the necessary capacity to certain extent, right? So young people, so common law say anybody can go into an agreement. But if we look at contract law, so meaning that we drafting an OTP or an agreement, that person or that party is going to make the offer, is going to sign it, right? Contract law says persons under the age of 18 should not actually be signing any agreements because they might lack the capacity to understand the content and understand the legal capacity and also the legal consequences of that agreement, right? People who have a mental impairment, that includes people with an intellectual disability, and people under the influence of drugs or alcohol, right? So for somebody to avoid a contract on the ground, to avoid them having the right to say, well, I didn't have the capacity, I actually shouldn't have signed this, and this contract is actually null and void. We should make sure that when we do transact with parties, that they are of age, of legal age, which is 18 and above, that they are not of an unsound mind, so they don't have a mental impairment, and they are not under the influence of drugs. Furthermore, also there are other legal capacities, not just for this, but also an unrehabilitated insolvent can also not enter into an agreement unless he's got explicit permission from the trustee that he or she might do so. Right. So make sure that we do our due diligence, and if we do transact, we should make sure that all the parties are of age, they are of a sound mind, and they are not unrehabilitated insolvents or under debt counselling, right? If any of those apply, a contract can be deemed null and void, and there are no legal consequences for that party that signed it. Right. Right. Moving on to number five, genuine consent. Both parties agree to the contract of their own free will, meaning that there is genuine consent for this contract to be binding, right? So nobody forced them, um, and they did it under their own free will, right? So there's a nice word for it, undue influence. That exists where one party exercises influences over the other, and is so the influential, and is so influential that that party cannot be said to have entered into the contract voluntary, right? Where the influence is said to be undue, the court may set aside the contract again. So, if one party can claim and they can prove that there were undue influence, that they were kind of forced into this contract, it can be null and voided, right? Mistake as to the terms and identity of the person again, and this is where we go back to a previous discussion where we should always identify and verify our clients, making sure that there aren't mistakes, that we are dealing with the correct person, that this person is the person that he or she claims to be, and that that is the legal person that can transact in that specific transaction. Right. Misrepresentation is the giving of false information by one party to another before the contract is made, again, which induces them to make the contract. If you make a contract in reliance of a misrepresentation and suffer a loss as a result, you can cancel that contract. So, and this is all things that us as property practitioners should do our due diligence on. So there aren't any loopholes for any party to say, well, yes, I wasn't of age, I didn't have the legal capacity, I didn't have the power of attorney to transact. You didn't transact with the correct person. I was under the influence of drugs or alcohol. I'm an unrehabilitated insolvent. I was of an unsound mind. We need to make sure that, as far as possible, that we check those things off so that there aren't any scapegoats for any purchaser or seller or any other party, in fact, to that agreement to get out of it. Right. And then that gets us to legality, meaning all of the parts of it, all the subject matter of the contract must be legal. Right. I mentioned earlier in a nice example, your terms and conditions needs to be legal. So any party of any agreement can actually put any consideration or any term and condition within a contract, but it should be legal. If it's not legal, then that entirety, the agreement in its entirety, is null and void. It can't be enforced. It is as good as nothing. Right. So if we talk about legality, again, a very good example is a drug dealer can't draft an agreement with himself or herself and a drug user, because the selling and the using of drugs in South Africa is illegal. Right, that's just a silly little example, but a very good one, making sure that all terms and conditions are legal. Right, so let's have a look at contracts of sale, lease, and management. Right, so let's first look at the definition of a sale. A sale consists in the passing of the title from the seller to the buyer for a price of immovable property. Right, so meaning that I'm going to pass on my legal capacity from my name onto yours through a legal process from the seller to the buyer for consideration in terms of monetary value. Definition of a lease, slightly different, but still the same. The transfer of the right to possession, meaning that the landlord says, I'm transferring the right of possession, so meaning you can use this property or the goods for a term, a specific term, in return for consideration, meaning in return for rent, for a monetary value, right? So more or less the same, meaning that there is always a transfer of something for the acceptance of a monetary value. Some there's a term, others not. And then it also just depends on if it is the actual title or if it's just the possession and the use of that title. And so I just want to come back to electronic communication and transfer. We said that yes, we can transact electronically. We are allowed to do that. It doesn't make anything null and void. But there are those two exceptions, and this is where those exceptions come in, right? So the object of this act is to recognize the importance of the information economy, right? So governments recognized that at some point it's going to become very difficult because of technology advances for people to always come together at a specific place, sign a contract in person, right? So that was to recognize that importance that we are advancing to facilitate the use of electronic transfers, right? To make it a little bit easier, to promote business and community confidence in the use of electronic transactions, right? So that we can understand that it is still legally illegal to do so, and to enable businesses and the community to use electronic communications in their dealings also with government. Right, it is for the purposes of a law of this jurisdiction, a transaction is not invalid because it took place by means of one or more electronic communications, like we explained earlier. The following requirements imposed under a law of the jurisdiction can generally be met in electronic form, right? So if we have a look at these, then it gives us a very good idea of whether this is legal and it can be enforced. A requirement to give information in writing, right? So again, we come back to everything needs to be in writing. A requirement to provide a signature. Yes, we're coming back to even if it's on paper or digitally, there needs to be a signature, right? A requirement to produce a document, a requirement to record information, and a requirement to retain that document, right? So not only are we going to process information, then also needs to be a way to keep record of it, and not just that, but also to retain or at some point destroy that document, right? If the time comes for that. Right, so for the purposes of this law of this jurisdiction, provision is made for determining the time and place of the dispatch and the receive of an electronic communication. Right, so there should be a way that one can track whether any party has received their documentation. Right, so when did they receive it? How did they receive it? Where did they receive it? The perpetrated originator of electronic communication is bound by it for the purposes of a law of this jurisdiction only if the communication was sent by the perpetrated originator or with the authority of the perpetrated originator. So again, it's only legal if the legal person has received it and the legal person has sent it. Right, we are just about done with module one. We are finishing up with just some last legislation, just to remind you guys again about unlawful activities. in terms of transacting. And one of those things that we're going to focus on are money laundering, right? The money laundering legislation, right? So this ties in with the FIC Act, the Financial Intelligence Center Act, also known as FICA. Again, it's risk based, so each and every single accountable institution should understand their risk and they should have a program, a RMCP, to mitigate that risk as far as possible. And we follow the guidelines in terms of FIC, which is the regulatory authority. And yeah, and this is where those accountable institutions come into play, right? So we did mention this earlier, but an accountable institution is defined as any institution that can be a victim of a financial crime, right? So financial crimes are considered the ones that we deal with the most or pops up the most are money laundering. That's where we take dirty money that was obtained from an illegal process, and we put it through certain processes to clean it up. And then the other crime or financial crime that we deal with quite often are tax evasion, right? So these are the financial crimes that occur most often. So in terms of Schedule 1, Clause 3 of the FIC Act, a property practitioner enterprise, and thus any property practitioner as defined in the PPRA or the Property Practitioners Act is deemed to be an accountable institution and as such must comply with the identification and verification process, proper record keeping and reporting. And we will go through that quickly as well. So in addition to the accountable institutions, FICA affects all clients or consumers entering into either a single transaction or a business related relationship with an accountable institution. Now, if we look at a single transaction, a very good example is the sale of a movable property. It's a single transaction, right? Once that transfer has been registered and the property has been registered from the buyer, from the seller into the buyer's name, and that transaction has been concluded. It's a single transaction. If we look at business relationships, very good example in our industry is a lease agreement, right? That's a business relationship. It's a relationship or transaction that occurs quite frequently, in most cases monthly, where the tenant gets the use of the property, the landlord gets the rent because of the use every single month for a specific time period, normally 12 months or a year. That's called a business relationship, right? So it's not a single transaction, it is a continuation, basically, of an agreement. So if we are an accountable institution, we've seen now that property practitioners and property businesses, we are identified as accountable institutions. We have duties that we have to perform in terms of the FIC Act, right? So establish and identify and verify your client, right? Again, guys, this ties in very nicely if we look at agreements, drafting of agreements, documentation, offer to purchases or lease agreements, right? There are information that needs to be obtained in order to be drafted within those agreements, and one of them are the details of the parties, right? So we have to make sure that we identify our clients correctly, that we establish that we are working with the correct person and that we have verified that, right? So verifying also KYC, know your client. That's the whole process that FICA refers to, and that can be done through those FICA processes that we did yesterday in the previous session, right? So each and every single individual, in terms of natural person or legal entity, there's a list that we need to obtain and verify, right? That gets us then to we'll get to reports suspicious transactions just now, but that gets us to keeping those records, right? So the FICA says we have to keep record of it. We can't just have a look at an ID document as an example, and give it back to the client. We have to obtain copies, and we have to keep those records right safe, either hard copies that needs to be filed correctly, in a place where it's locked away and not just anybody have access to them, or it needs to be saved on a secure cloud with quite regular backups as well. And when FICA says those records have to be kept for a minimum of 5 years, right? We have the duty to report suspicious transactions, right? So if clients are hesitant to give us documents that we have requested, or funds that they are using to purchase property seems to be suspicious, or it's huge cash deposits that is available, or clients bring cash to your office and they want to put that cash into your trust account. Those are all suspicious transactions, suspicious individuals. And FICA says that we have to report those suspicious transactions, and we do that also via a specific process that is stipulated on the fixed site. Right, and then we have the duty to formulate internal rules. So each and every single office within that a property practitioners work under should have internal rules on how they identify their clients, how they keep their records, how they report suspicious transactions, etc., etc. Right, and this forms part of that RMCP program where we identify our risk. We try to mitigate it as far as possible, and we use our internal rules, policies, and procedures to tie in with the FICA law. Right, so additional responsibilities that we have in order for us to act as an accountable institution, meaning that we are acting as property practitioners, we are working as estate agents. We should be registered with the FIC Centre, right? So your office or your business should be registered with FIC Centre. You should have a FICA manual in your office, which must be displayed and easily accessible by all the employees in that office. You should have a risk manager appointed. Previously, we called that a compliance officer. So it's somebody in the office that, again, has the capacity. So it must be a qualified person, a qualified property practitioner that has been qualified for more than 3 years. That person is the risk manager. That's the person that you will report to first if there are suspicious transactions or suspicious individuals that you are transacting with. You should have a risk management compliance program. Those are those internal rules. It should be developed and adapt a specific type of risk mitigation. So your business should have rules on how we can mitigate risk. One very good example is before we even start transacting with a client, we should FICA them, we should know our client, and we should ask them where the funds are coming from, right? So identifying and verifying our clients. All staff should always be trained on the requirements of FICA, and it should be quite a constant training as well, and regular training, even if it's just refresher courses every year, right? And then you should identify and verify the identities of every client which we transact with, whether it is that single transaction, whether it is a business relationship that we transact with. Again, we should develop a record keeping system in not just keeping records of clients, but also all transactions, whether those are those single transactions or the business relationships. And we should always report suspicious transactions to FIC, because law says that we absolutely have to do that. In terms of all these laws, we have worked through quite a bit of information in these past three sessions. But in terms of all the laws, one thing that we should always take in consideration and never forget is there are consequences of non-compliance, right? There are laws and code of conducts in place for a reason, and if we don't comply with them, there will be consequences, right? So if we just quickly look at non-compliance, anything that the PPRA forces us to comply with, you as an estate agent can lose your certificate. You can be, if you are found to have transgressed any laws, and you can also be charged with conduct deserving of sanction, meaning that you can't be a state agent anymore, right? If we look at FICA, failure to comply with the Act can result in penalties. It can it can be financially detrimental to not only yourself but also to your company. Fines up to 10 million rand or imprisonment of 15 years. Right. So thus, any agent who does not receive FICA training is prevented to work or transact with members of the public to avoid any penalties or imprisonment. Candidates, this concludes Module 1. We are completely done. Again, if you have any questions, queries, or concerns, please don't hesitate to reach out to myself or Tim. You are equipped now with enough information and knowledge to do your assessments. These assessments are due, so please work through them and enjoy. If you have any questions, please make contact with us. We are making better agents of you guys, and thanks for joining us.